you. Rob, I wasn't here earlier when you mentioned the initiative to running. You said something about Arizona. My question to you is it safe to assume that we're waiting on the election results to see if Prop 105 passes before you dedicate any time or anything to Arizona?
Yeah, that's correct. The initiative that you just referred to is an initiative that's on the ballot in Arizona this November 4th, which would amend how initiative votes are cast in the future. If that bad initiative passes, then it would be impossible to pass any initiatives in Arizona on any issue in the future. It's a technical explanation for why it is, but it's a very bad anti-initiative initiative. So we're waiting to see if that thing fails before we can proceed. However, the good news is that even if that bad initiative succeeds on November 4th, we're going to sue, and I'm told by our attorneys we can almost surely win because it violates the principle of one person, one vote. If that initiative passes, it counts dead people as no votes, and that clearly violates the principle. Clearly violates the principle of one living person, one vote.
I thought it was only Chicago where dead people got to vote. Doug?
This is for Mr. Alford. It was great news coming in yesterday reading about San Diego, the San Diego case, but apparently they've already said that they're going to petition the Supreme Court for cert. Do you think that has any chance of succeeding? I mean, 3 years ago we lost the Supreme Court. I don't know if things are different and what the issues presented are. And also apparently Garden Grove is going to be asked to the Supreme Court for review on that case. If you could talk about that.
Both those issues, is that on? Okay. Yeah, both those issues, or both those cases, give me the heebie-jeebies. As certainly we don't want to end up before the U.S. Supreme Court on any medical marijuana issue. It was a nice little victory yesterday to hear that the California Supreme Court at least has denied San Diego's petition for review. None too surprising, San Diego is going to take that case up to the U.S. Supreme Court. And we could actually win that one at the U.S. Supreme Court. The city of Garden Grove has already filed their request for cert with the U.S. Supreme Court. The U.S. Supreme Court has requested a response from us, which you'll probably see me feverishly working on as I do some tabling here at the conference, since we got to get that out on Monday. But I'm hopeful that the Supreme Court will not take either of the two cases.
As you may know, folks, San Diego NORML was actually named as one of the defendants in that case. I'm happy to say that the ACLU attorneys that were taking on that battle also represented our interests. Obviously, we were all pleased with that decision yesterday. Yes?
This is also for Mr. Elford. How will the Kelly affect the Attorney General guidelines, and do you think the Kelly in the other case will win in the Supreme Court, or will prevail, or?
Oh boy. Yeah, Kelly's probably about one of my least favorite topics to talk about. At this point. Actually, it doesn't really affect, the guidelines actually anticipated both Kelly and Compacti being heard by the California Supreme Court. And so I actually don't think it will affect the guidelines other than the part that talks about limits. There's possibly a challenge to the AG guidelines insofar as they affect limits. ASA may or may not be a party to that lawsuit.
By the way, for the rest of it, is Kelly the decision that said SB 420 may not be valid? Is that the one?
Yeah, the Kelly decision, law enforcement was using the SB 420 quantities as caps, as ceilings, and busting anyone above those quantities. And the prosecutor used that theory at trial to convict Mr. Kelly. And the court found that to the extent that SB 420 actually does constitute limits, that would be an unconstitutional amendment of the voter approval.
Now, that was a state court of appeals decision, correct?
Yes, and it's currently, the California Supreme Court has agreed to grant review of that case, so that case is going up.
Yes, sir.
My question's for Joe, and that is under the Attorney General guidelines for card holders. It seems like there's two different ways law enforcement will carry out whether you have a state card or a non-state card. It looks like state card holders have more protection than non-state. Is that true in the reading?
I don't think so. I mean, we were very careful. I mean, it's our, otherwise you're turning voluntary ID cards into mandatory ID cards. So they do different things. So if you get pulled and you have an ID card, they would chuck it through the ID card system, whereas if you don't have an ID card, they might call the doctor. But the protections themselves ought to be the same. even though I know it's worded more strongly sometimes in the context of ID card.
Yeah, it is. It seems like non-card holders have less protection. If you read the guidelines.
Actually, not in my read.
Is it an issue or?
I mean, it would be an issue, but not in my read of the guidelines. I mean, the guidelines say, even for non-card holders, the cops should still not seize your marijuana and shouldn't arrest you, and that's basically the same, same protection you get if you have the ID card.
Okay, so once again, they're equal.
In our opinion, yes.
Okay.
Or it should be. I mean, other than the procedures are different,
Yeah, the procedure.
but the protections ought to be the same.
Okay, thank you.
We have maybe time for both of you if you were fairly short. Thank you.
Yes, I'll be short. A variety of states have passed a collection of marijuana initiatives of various sorts. What is the impact on travel arrangements as far as going from one state to another and the interaction and the reciprocity? Is that the right word? Reciprocity. Thank you very much. All right, so if someone feels knowledgeable about that subject or to come on it.
Well, let me start off, and then I may kick it back to Joe, who may have more to say. Generally, people need to understand that reciprocity is a civil concept, not a criminal concept. So if you have a driver's license issued by the state of Virginia, in my case, I can travel around the country, and other states give me full reciprocity. I have all my driving privileges. Unfortunately, there is no similar concept for criminal matters. So even though you're protected under California law, for example, if you're a medical user who followed all the rules, you drive to Arizona. I just got a call the other day, and I guarantee you that Arizona did not respect that California protection. So occasionally I hear stories that are positive about that, but at least legally, there is no such thing as full faith and credit on criminal protections. Joe, somebody else?
Yeah, I mean, of course, it's always going to remain illegal under federal law because you're crossing state lines, but I'm not aware of any state that gives any kind of reciprocity, although it sounds like Dr. Lucido might be.
Frank?
Yeah, Montana, that's the one good reason I tell people the state card might be useful if you're going to Montana, because Montana is the only state that has reciprocity if you have a state-issued ID card, although Jim Sweater has talked about that whoever's selling cannabis recognize the other ones too, but the state says reciprocity if you have a state-issued ID card. The only other reason to have it is if you live in Placerville or some other place where cops don't follow the law, it might give you a little extra protection for the state card.
That's true.
In Jerry Brown's guidelines, it's mentioned enough that maybe it gives a little more.
Yeah, good point, Frank. Although there's no common law right of full faith and credit or reciprocity in the language of the Montana Medical Initiative.
And travel doesn't,
Is Rhode Island also? Good for you. Thank you, folks. Yes, one more.